Bose and Justice Ramanna and others have concurred. It is a constitution bench. All have concurred, but they have separately recorded concurring views. But this view of my Lord Justice Keher is for 3 honorable judges. We may therefore summarize our conclusions as under. Firstly, the measure of discretionary power of the governor is limited to the scopes postulated, therefore, under Article 163(1). Secondly, 163(1), the discretionary power of the governor extends to situations wherein a constitutional provision expressly requires the governor to act in his own discretion. We are not concerned. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. This is important. Fourthly, in situations where this court has declared that the governor should exercise the particular function at his own and without any aid or advice because of impermissibility of the other alternative by reason of conflict of interest. After relying upon MP judgment, another constitution bench judgment is pleased to say this, my lord. Then concurring view of my Lord Justice Lokur at the foot of page 50,
Yes.
para 362. The development of constitutional law in India and some rather peculiar and extraordinary situations have led to the evolution of a distinct category of functions in addition to those postulated or imagined by the Constitution and identified above. These are functions in which the governor acts by the Constitution and of the constitutional necessity in view of the peculiar and extraordinary situation such as that which arose in MP Special Police Establishment Act, cited and approved, and as arise in situations relating to Article 356 of the Constitution or in choosing a person, etc., etc., my lord. My lord, similar is the view in concurring judgment, my lord. Last, Nabam Rabia does not dilute this. And my lord, Nabam Rabia also, my lord, my learned friend had the honor of assisting the court. So was me, my lord. I also assisted the court. So I am aware, my lord, this is not diluted because constitutionally speaking, it is not capable of being diluted. And likelihood of bias in the decision of the cabinet, my lord. I have cited judgments, my lord. I may not.
Reasonable man's theory.
Yes, my lord. Lord, time taken during grant of approval for investigation, my lord, they say that I acted hurriedly. Lord, please, my lord, see, I have shown, my lord, the list of dates which I have taken from their record only. And my lord, please allow me to read this para, my lord, so that there is no hurry, undue hurry or something, my lord. He attended to, within 2-3 days, issued notice, heard, then charge prepared. It's not as if, my lord, I received the complaint today and I grant approval today. Well, sometimes, my lord, what happens is, when we are dealing with constitutional functionaries, our pleadings as well as our submissions must express that respect. My lord, to show that friendly governor or the respondents have given comical replies, Lord, does not behove a constitutional functionary who is the Honorable Chief Minister. But I didn't say anything against the Honorable Chief Minister because he's a constitutional functionary. There can be several adjectives I can use. Merely because some individuals have filed a complaint, they do not become subject matter of a laughter or you being my lord, labeled as comical or something. My lord. But please see, my lord, on this, it is submitted that petitioner has raised the false issue of issuance of a show cause notice dated so-and-so on the same day as the receipt of petition of respondent number 3 seeking grant of sanction for prosecution. In this regard, it would be relevant to point out that the Honorable Governor was made aware of larger issue with respect to rupees 4,000 crore scam in relation to the irregularities in allotment of land by MUDA much before the issuance of show cause notice. In order to discharge his duties as the head of the state of Karnataka and to ensure that the government was working in accordance with the constitutional principles, the Honorable Governor deemed it fit and appropriate to seek a detailed report from the Chief Secretary of the Government of Karnataka In furtherance of the aforesaid, the Honorable Governor wrote 2 letters dated so and so. My lord, they have filed in the petition. I am not, my lord, placing any other document on record. That is 5th July and 15th July. In reply to the above referred facts, the office of the Honorable Governor received a letter in the form of a report from the Chief Secretary of the Government of Karnataka dated 26th July 24. That is again placed by them. It is submitted that the narration of facts in the said report is verbatim and factual narration in the decision of Cabinet.
Yes.
My lord, your lordships are at page 54. my lord.
Yes, yes.
Cabinet dated 1/8/24 and the reply of the petition. So it was going on. He was seeking information, and at that stage, Mr. Abraham came in person. He was examined. His authenticity, his identity was, my lord, established. And my lord, immediately the notice was issued, my lord.
No, but
Me-
whether a decision taken in hottest haste, would it vitiate the entire thing?
Thing, my lord, when mere issuance of show cause notice would not show undue haste, because thereafter he gave
So
sufficient time.
this is show cause notice, a little step further also.
Thereafter, my lord, there are.
If a decision of
Yes.
the state is taken in a hottest haste,
Yes.
whether that would completely vitiate the entire.
It cannot
decision.
vitiate, my lord. Sometimes, as a constitutional functionary entrusted with the constitutional power, it may be required that the moment he comes to know about it, he has to immediately approve
No, this, yes.
investigation. That yes, I am passing 17A, you start immediately. This cannot brook delay. Sometimes a delay may result in, my lord, an allegation of his dereliction of. Then, my lord, I have already said the contention that I have not taken any decision, I have not made any recommendation. Then why are you bothered? Then you are like any other ordinary offender. Then 17A is not required. Then why should you challenge the approval? You say that 17A is irrelevant. 17A cannot be relied upon because I have not taken any decision. I am not going into the facts where his role comes, how he benefited himself comes, how the Prevention of Corruption Act is, its architecture is couched. Even the beneficiary is an offender. That etc. etc. But it would be premature for me to arrive at any conclusion, record any conclusion, or argue before your lordship. I have only said that yes, needs investigation, you investigate. My lord, these are my respectful submissions, my lord,
Yes.
and I have, my lord, given judgments on this
Yes.
point, my lord.
I'll-
So,
It's quite elaborate and it's,
my lord, I'll not, my lord,
yes.
trouble your lordships, my lord. Kindly treat them as
One
read.
constitution bench judgment,
Yes.
Justice Y.K. Sabharwal, I think, 2004, 3 SCC. Even a decision, not this is only a notice being issued. Even a decision taken in hottest haste would not vitiate the
Yes,
decision.
I am aware of it, my lord. I'll just.
Says that went from this state where KADB allotments were made in hottest haste. That was it starts with SP or something. Justice Y.K. Sabharwal.
I'll find out and place for my lord's kind
Yes.
consideration. My lord, it was really pleasure and privilege to assist your
Sorry,
lordship.
yes.
Obliged to your lordship.
Yes.
My lord, these are the full text of
yes.
the judgments which I have
Need
already
that.
cited, man. I'll give the copies to my learned friend.
मैं थोड़ा इधर कर लूं
हाँ, कर लो. Lord, can your lordship pardon my absence only for
Yes,
5-7
yes,
minutes?
yes. Madam. ಇದನ್ನ ಒಂಚೂರು ಕಳಿಸಿ, ಮತ್ತೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ.
May I start?
Yes, sir.
My lord, I
Sir,
beg to
you are
appear
appearing
for
for the
respond number 4, my lord.
respond number 4.
And I will not take much time because, my lord, your lordships have heard it repeatedly by various persons. My lord, only thing is Mr. Raghavan, my lord, was to be here. He's not here. He'll just supplement, my lord, with your lordship permission for 4 on Monday. My lord, I have a very humble submission, my lord, from the different perspective. From the perspective of a complainant, my lord, who feels aggrieved by the violation of the public trust in a democracy by this process, my lord. Before I begin, my lord, just make a note of 3 figures.
Yes.
The three figures, my lord, in my respectful submission, which falls for your lordship's kind consideration, is 3,24,000, 3,24,000,
Huh.
5,98,000, and approximately 55 crores.
Yes.
The land in question, and I'm arguing, my lord, from the facts which have now come from their repeated same note. And they clearly inform this honorable court in the papers that the land of 3 acres plus 3 acres, 16 guntas, which became a part, and this is something important, became admittedly a part of an acquisition process which commenced in 1992.
Land was acquired?
Land was, their case is that it should release. My complaint, it should acquired, could not have been released, everything is void. But before that, my lord, to say, my lord, that when we are in 226, whether he filed it or I am standing here, but your lordships are having jurisdiction under 226 for investigation into apparent corruption, should not get, my lord, restricted by any objection, technical or otherwise. I'll come to that, my lord, in Mulayam Singh Yadav's case, my lord. I'll show to your lordships in no time. My first respectful submission I said submitted, my lord. Land approximately 3 acres, 16 guntas. And I, my lord, these facts are admitted, and wherever they are not admitted, they will be my submissions. Part of a acquisition process for some third phase in this scheme, my lord, in 1992. Any sale or transaction after this, my lord, notification which is issued in 1992 is void, except for the fact that a purchaser who's a bona fide purchaser, my lord, in a lawful manner may claim only compensation. Something more, my lord. A subsequent purchaser who may just get into the shows only for compensation, can't even ask for challenge to acquisition, can not get any benefit of any land policy or an alternate land. Supreme Court has directly decided it. Therefore, the land acquisition process having commenced in 1992, concluded, my lord, the final notification in August 1997. Possession taken, and I am going to cite, my lord, Indore development on two aspects. What is the concept of possession taken and what is the concept of compensation paid or deposited? Few paragraphs. But the relevant facts are 92 first notification, 97 final notification, land acquired, possession taken, and something more important. Please make a note of page 94 of the writ petition document filed by them. The revenue record records the MUDA as the owner in 98. 94.
Yes.
My lord, in the middle of the paragraph, in the middle of that page on the top, your lordship will see the ownership and possession of MUDA.
Page 94.
Page 94, my lord, in this table here.
Yes.
I can't read it, my lord, I
No,
have
it's
the
all right.
handicap.
Yes.
But this is where MUDA is recorded. This is 98, 99.
Yes.
And, my lord, compensation, my lord, is determined. Award is made.
Yes.
So first notification before May 1998, which is the so-called de-notification. First notification 92, final notification 97, award 1998, and, my lord, entry of revenue record 98. Therefore, why investigation needed? There is a colossal fraud, my lord, of creating a case for release of the land under section 48. 48, my lord, whatever little I know and I have learned, my lord, with the moment possession is taken, even on a paper possession, the land acquisition is complete, the land vests in the government. Thereafter, 48 is not available. I'm not saying, my lord, I'm not arguing to justify that some 48 is illegal. I, my lord, as a citizen is paying and a justification with material on record, now confirmed by them of an investigation. So 3,24,000, where all this facade, my lord, is ex officio fraudulent. And the Supreme Court says any transaction after section 4(1), that is the first notification, renders every transaction thereafter void except entitlement to receive compensation. Now, my lord, see what happens. So the land, my lord, which stood recorded in the land revenue record in the name of MUDA in 98, admitted next fact. Even when their grievance is, even when then it is, there is a release notification, it is not released, it is developed as a development. My answer, my lord, as a citizen is, this was never released. It could not have been released. Therefore, it continued to remain in possession of MUDA. It continued to remain a part of the development scheme. Plots developed, sold from 2001 to 2004. Plots developed on this land, acquisition completed in 98, award made, compensation deposited, etc. I will come to one more document. Development completed, plots sold by written document. My lord, the learned AG was a little uncharitable in his note saying it's only a paperwork. My respectful submission is the entire thing to the contrary is paperwork. So 2001 to 2004 plots, sale deeds are in existence. Sold. Now, my lord,
The very same lands.
very same land, admittedly, it is no more remain, and I am having a one more grievance, my lord. In the cabinet note, a writ petition order is cited. The writ petition order, particulars of the writ are not given. Order is not shown. And the foundation is made for giving these 14 sites to the petitioner's wife on the ground that High Court has passed an order of a same nature in a similar case. Why the curiosity? Where is the judgment? Let us see this judgment. In, my lord, 5 notes of the same kind. Fortunately, my lord, somebody gave the number. I've got that order. Kindly give the copy, sir. Udhar bhi do. This is the order, my lord. I'll show to your lordship as a part of the cabinet note, part of the opinion. In, my lord, at some place, number is given in the opinion, number disappears. The read number disappears. The name disappears. Similarity remains. Now, what is this case? Somebody,
This is all the order?
this all is the order. I'll show to your lordships. Just give me one moment, my lord. I want to say something. This is available, downloaded from the High Court site, my lord. I'll show that, my lord. In any case, they will have something more. Somehow you have to justify this release. Right, my lord? Which release is ex officio, my lord, prohibited by law. Could not have even been thought of for without fraud, my lord, without fabrication, this could not have been executed. Right, my lord? So some justification is to be made. So some Babu who must have prepared a note, took the, my lord, risk of mentioning the writ number and the date of the order. Somebody must have advised her, make it as a part of justification. This land, my lord, was never a part of any acquisition process. Never.
But the subject lands were.
In my case, it is land acquisition award made. I say, sir, I'm coming to the notification, don't worry. This is the parity shown. And this one-page order, my lord, which the details are missing in the legal opinion, is in a case, my lord, because somebody could have easily understood it is no parity at all. If you cite it and give the particular, somebody reads it, he will shout like me. And I'm shouting. Because nothing becomes available without shouting nowadays.
Not everywhere, not necessary, sir. Yes.
After shouting also, no. You're confident? Very well. So, my lord, no acquisition process at all. It was a clearly an infraction of Article 300 capital A. Somebody includes your land without even putting it in the notification. So the High Court says, return the land. You have not acquired it. You are free to acquire it. Obviously, if you need it, becoming a part of any scheme, acquire it. Free to acquire it. You never put it in any acquisition. There is never any award. You have included into your development. Please release it. Release in the sense, not 48. Give it back. Restore it, restitute it. There is a difference between release and restitution. This is not a parity. Now please see the pages. Second volume of the writ petition. And my lord, my respectful submission is not, my lord, to create a sensation or something. Mine is that it requires investigation. Now kindly see, my lord, first of all, page, my lord, 275. This is a part of my dear friend, my lord, my dear friend's client, my lord, Shashi's client, who have given a note, the Cabinet Secretary on 26/7/24. Right, my lord?
Yes.
At page 275, please make a note of para 24. I'll just read this four crisp and, my lord, sweet short lines. In a similar case, the land of Shrimati so-and-so, Mysore Taluk number so-and-so, detail of the land is given, had been developed for layout without following land acquisition process. So, my lord, please see. Supposing I say the land is never put to any process of acquisition, it is one thing. Not following the process of land acquisition process in accordance with law is another thing. It is a case where there is no land acquisition process initiated. And please see the next line. Petitioner had filed a writ petition and order dated 22/1/20. The Honorable High Court has directed. No mention of any number with writ petition. Who directed, when directed, nothing. Now, my lord, just go to this, my lord, second similar thing, my lord, at page 289.
Yes.
It is, my lord, the part of the learned AG, my lord, Shashi's opinion, which starts at 279. And kindly see para 6.24.
Yes.
Now, my lord, supposing with this order, which I handed over to your lordships,
Yes.
a meeting has to take place to comply with that order or to challenge that order. So meeting must have taken place. Now, my lord, this meeting or this order had nothing to do with the present case. And this order meeting is that it is never become a part of any acquisition process. Therefore, you are violating its fundamental right of ownership. Return it. Or you acquire it. Now, my lord, after this, your lordship may kindly come to page 352. Which, my lord, is a part of yes, my lord, at page 336, the reply, the cabinet meeting, my lord, the cabinet note.
Part of the cabinet
To
note.
the show cause notice, my lord. Kindly see this starts at 336
Yes.
and kindly come to 352 5.24.
Yes.
May I read this, my lord, with your lordship
Yes.
permission, one paragraph. In a similar case, the land of, so, my lord, first 5 lines are verbatim, which I read the note earlier. But somebody forgot that this number is to be removed. And, my lord, this is repeated, there is no number, etc. And then your lordship may kindly come to page 352. My lord, the writ 5.24, writ petition number 56604. and the date of the order which I have handed over to your lordships.
Yes.
So when somebody, my lord, in a routine prepare the note, the numbers come, details come, because the parity is the founded, it is one of the main documents for giving this order,
Take the copy.
for taking this decision. That the way you have returned that land of 2 acres and some guntas, please return this also. That was never a subject matter of any land acquisition. This is land acquired, award made, entries made in the name of the government, etc. Now something more, my lord, something very curious. Kindly come to, my lord, page 509 and 510. मैं वही बता चुका हूं, तू था नहीं। मैंने ये बोला।
Yes.
I'm not arguing for this.
Hmm.
509 and 510. Please mark the date, my lord. So a
Please.
cabinet note is to be prepared and some justifications are to be created. So, my lord, such kind of vague documentation is generated, engineered, and I would not say fabricated at this stage, because that would be a subject matter of investigation. I would say generated and engineered, because that may not sound comical, my lord. It may still be very respectful. So it's engineered, and this engineering is here. It's a classic piece of engineering. What is that? Sir, we took the possession, we completed the process, but money was not taken by him. The compensation money. My lord, I can't read this. If your lordship may kindly have a look at that. I am told, my lord, it says, उसने पैसा नहीं लिया. Therefore, in no development, पैसा लिया नहीं लिया, land acquisition process is complete.
नहीं, पैसा दिया है, लिया नहीं है.
पैसा दिया, उसने लिया नहीं. So that indoor says nothing. It's complete. That is why I said I am going to cite two paragraphs each, both, my lord, for the completion of the process, kabza taken, possession taken, and, my lord, the money tendered or money even kept aside. Straight away, my lord, now 509 and 510. And, my lord, your lordship may just make a note along with this. This is 4 July. This is one day before page 597.
597.
Yes, my lord, 597. Now, whether it is because this is 5th July. 5th July, my lord, it is sent. So, my lord, whatever is to be done is to be done. I am not saying it is antedated. This letter, my lord, at 510, one day before this letter is received from the Honorable Governor, it would be investigated. Right, my lord? So I gave your lordship two figures, my lord. 3,24,000. And, my lord, when this has all happened up to 2004, the land stood developed. The sale deed for the developed plots executed. 2004, a sale deed takes place of agricultural land which stood developed and became non-existent. Because, my lord, the land is developed and the plots are sold, there is no agricultural land left.
No, how did it become agricultural again?
Well, that's the magic.
There's no order for that.
I hope that if your lordships are convinced, my lord, the investigation must take place, the IO should be equipped enough to find out. Or I'll only pray to the Almighty.
Yes.
No, but kindly see, my lord, it's a very serious issue. My lord, it is thought to be trivialized by this repeated process of repeated notes. And when the Supreme Court says the governor will act independently, a resolution passed to pressurize him by the cabinet. Kindly see, my lord, the impact of it. You are not supposed to do it. You are not permitted to do it. And you do what the law forbids to you to do. And how? As a cabinet. And then we, my lord, keep on banging, my lord, the doctrine of public trust. This is what public trust is, with which we are faced. And, my lord, it may, our replies and our demand may be sound too comical to the other side. But my lord, if in this case, we are not able to persuade your lordship to discharge your lordship duty as a court, which I will show, my lord, then it may be tragic, if not comical, as my learned friend used repeatedly. What is to be done? An investigation. Supreme Court says no objections to be allowed to come in if it is investigation, provided you are prima facie satisfied. My lord, even for framing of charge, my lord, which is after the cognizance and after section 19 and 197 stage, even for framing a charge, one judgment I'll give it to your lordship, my lord, weaker than prima facie case. Strong suspicion, reasonable suspicion, etc. Supreme Court went to the extent of saying weaker than prima facie case, even for framing a charge. Here I'm saying, my lord, ex facie, established case, acceptance of the Honorable Court for facilitating and permitting the conduct of our investigation by an independent agency. Number two, my lord, when unison replies by the government, by the cabinet, by the law authorities, how will this investigation be done by any state authority? They have taken a stand before your lordship, which is unison. My lord, I'm with utmost responsibility saying unison. It is verbatim the same. So if I am right, my lord, in begging that it needs an investigation, it can't be either by them or by my learned friend, Mr. Chachi. Now, my lord, in this background, kindly come to a couple of judgments. First of all, on the public trust doctrine.
You have your written submissions also?
I will, my lord, I've got it. Some corrections are to be made. Before I leave, my lord, or by tomorrow or day after tomorrow, early morning, it will be available.
Yes.
I have also taken the liberty of reproducing the relevant paragraph so that
Yes, yes.
this, my lord,
No, all that you submitted now. If it is in the written submission.
unfriendly, my lord, environmental behavior of ours may, my lord, get restricted. Now, my lord, first judgment which your lordship may kindly see. अरे दे दो ना यार, ड्रॉप कर दो. नहीं, वो भी दे दो, सॉफ्ट कॉपी भी दे दो. But this is 1994 supplement 2 SCC 116.
Yes.
Where, my lord, the grant of consent was sought to be withdrawn, where, my lord, also happened here day before yesterday. I have yet to see your lordship judgment in the other case, my lord. I just wish to read, my lord.
Division. I thought what I heard. Yes, yes.
My lord, kindly come to page 8, para 15.
Yes, I'm there.
I'm sorry, my lord.
I'm there.
So, my lord, my lord, I will only leave the para number, which also, my lord, I have experienced is not needed to be given here.
Yes.
Even if we don't leave the judgment without number, anything will work. The way, my lord, the denotification has worked. No number, nothing denotified.
Yes.
Now, my lord, para 15, your lordship may just mark it.
Yes.
Then kindly come to the second judgment, my lord, and your lordships have
Yes,
dealt
yes,
with.
yes.
Your lordships have dealt with, my lord.
Yes.
And kindly only make a note of para number 52.
Actually 56.
54 to 56, my lord, if your lordship.
56 is what is.
Yes, my lord, your lordship, right? 52 to 56 are citing, but your lordship may kindly restrict it to para 56.
Yes.
Then, my lord, one paragraph which I wish to read, which is at page 64 of this paper book, is not that, my lord, Mohammed Ramdan Khan inquiry report, my lord, that constitution bench under the Central Tribunal Act, my lord, Karuna Karan.
Yes.
This is the similarity of name with a greater population country where names are common.
Yes, this is
In-
K. Karunakar.
So,
That is
my lord,
B. Karunakar. Yes.
my lord, in my community that we have so much of shortage of names, my lord, that the girl and the boy will have the same name. So 140 crore people, they find it difficult to have the.
My learned friend, my lord, who was my colleague, Mr. Maninder Singh, Additional Solicitor General, and we had Mrs. Maninder Singh Acharya as Additional Solicitor General. Even
That's right, this
in
is-
case of Navjot Singh Sidhu, his wife is also Navjot Kaur Sidhu.
this only shows, my lord, a common feature in our society of shortage. 8, my lord, para 8.
Yes, sir.
And first 5 lines, para 8, my lord, that if a case is made out for any, my lord, investigation, then there should not be permissibility for any technical or other objectives. Court would, my lord, discharge its duty that which, my lord, would facilitate and, my lord, ensure that the investigation is carried out. My lord, I can pause here for a moment, my lord. The learned solicitor has
That
explained.
case of the Kerala Chief Minister, K. Karnataka.
Yes, my lord. I just want to take 1 minute here, my lord. It is not needed. But, my lord, your lordships have seen, your lordships have gone into these 2 judgments, my lord, which have now become the foundation of the circular, my lord, of your lordships High Court, which have gone. I just want to say one thing, my lord. It may also, with the development of law on section 17A, it may, my lord, require a little tuning, etc. Because I tell your lordship why, my lord, what I feel and very humbly submit. But the preliminary inquiry, my lord, as we know, in the ordinary normal state police, it is FIR under the CR. Your lordships have dealt with many cases of CBI. There are 2 concepts, my lord. First is PE and then RC. The FIR is equivalent to RC, registered
Yes,
case. They say registered case RC.
By the CBI.
And P is preliminary inquiry. My lord, the preliminary inquiry was by the mandate of the Supreme Court in a case called Sirajuddin, a public servant, my lord, where they said that if the FIR that are direct, my lord, permitted to be registered day in and day out against public servants, their functioning will become impossible.
That's what is followed in Lalita Kumari prior to paragraph
So
120.
they have repeated Sirajuddin
Yes.
in 116 and 117.
Yes.
My lord, Sirajuddin judgment which gave this birth to the concept of PE, then, my lord, was also, it got an entry into the CBI manual. It became clause 9 and 12, my lord. So
That's why they register P and then RC.
then RC. Now, but as, my lord, held in Lalita Kumari also, if the blatant, if the cases exercise can be seen even on the allegation on the information, even when there is a permissibility of PE, it is not a must. You are free to register. You are obliged to register a case, my lord, which is Lalita Kumari. So, my lord, I need not go into this because 17A is one, my lord, one area which is now pre-investigation only.
It's still
only-
little gray.
Exactly. So, my lord, if a circular goes that your complaint or your grievance redressal before the criminal competent court would be only with a permission under 17A, if that is to be appreciated and understood by the courts, then, my lord, whether I applied it on 4th of July or 31st of July is immaterial. Because as a citizen, what I need, investigation must be carried out. If something is required, must be done. The courts will decide whether it is required or not. As a citizen, I do not want to get with a stumbling block. That in my seeking my redressal through a process known to law, if there is a requirement of this approval, I must approach for approval and I must get approval. The court will decide whether approval is needed or not. That can't be read as, my lord, something which is comic. Therefore, my lord, now in that background, kindly come to para 36 of, my lord, the judgment in Vishwanath Chaturvedi's case, where, my lord, kindly see, my lord, kindly come to page 66.
66.
Yes, my lord. Vishwanath Chaturvedi. Kindly mark it, my lord. It is writ petition under Article 32.
Yes.
Kindly mark it, my lord, on the top. Your lordship will get a writ petition.
Yes. Yes.
So, my lord, some allegations against the Chief Minister of Uttar Pradesh. A writ petition come directly to the Honorable Supreme Court under Article 32. The law is discussed and the direction is issued, including para 36. Before that, my lord, I just want to show 2 paragraphs. Para 33 at 79. Para 33, page 79.
Yes.
In our opinion,
Yes.
the minuteness of the details furnished by all the parties and the income tax return and the assessment order, sale deed, etc., have to be carefully looked into and analyzed only by an independent agency. So, your lordship, I beseech you of your lordship's indulgence to keep in mind independent agency. And especially when the stand of everybody is unison, verbatim, that nothing has been made out. Carefully looked into and analyzed only by an independent agency with the assistance of chartered accountant and other credit engineers, and values of the property. As stated by the petitioner, very valuable properties in the heart of the city have been purchased for lower consideration and less than the market value. Please make a note of the third figure, my lord, 55 crores. 3,24,000, 5,98,000 is the sale deed of 2004 of an agriculture land. And my lord, 14 developed plots of land now given, my lord, which is worth not less than 55 crores. Otherwise, some statement made here and there on the media, my lord, more than 60 crores. So this 55 crores, which you have got, I ask this question, why should it not require an investigation? What did you pay 6 lakhs in 2004 in a fraudulent transaction? Prohibited, not permissible, because there is no agricultural land available in the name of that original person. Nothing. And through this process, by relying on a similar case which is not similar at all, you have enriched for yourself or your family member at least 55 crores. ₹55 crores. And what is your lordships are considering at the hub of the matter? Should it be investigated or not? I'm saying, my lord, supposing there was no 17 and nothing. The petition is before your lordships are under 226. The criminal jurisprudence is locus neutral. Your lordships could do it suo motu. Your lordships are having a proceeding where 226 is invoked for praying for a criminal investigation. My learned friend client obviously has come to stall it. Your lordships are fully equipped to pass an order here itself if your lordships are satisfied that 55 crore is a bounty, which is a clear ex officio violation of the public trust by a public servant. Please see, my lord, PMLA section 3. A beautiful 2 words, my lord, in PMLA, which I didn't see except for 120B. A process and activity. Kindly read the process here. Please see the process. Who has got benefited and how much? And at what cost? Process, activities. Now, my lord, please see 36 at page 80.
Mulayam Singh Yadav.
He is a senior politician. Caesar's wife should be above suspicion. Kindly see. I'm not talking wives literally, my lord.
I know.
I don't mean to say anything, any disrespectful thing to anybody.
Yes.
He's a senior politician and holding a very high public post of chief minister in a very big state in India. And the allegation made by the petitioner against him cast a cloud. I am, Lord, I am in submitting. My case is much better higher. It's not a cloud. It is ex officio demonstrable. Have cast a cloud on his integrity. Therefore, in his own interest, it is of utmost importance that the truth of these allegations is determined by competent forum. Such a course would subserve public interest and public morality, because the chief minister of a state should not function under cloud, and that it would be in the interest of respondent number 2 and the members of his family to have their honor vindicated by establishing that the allegations are not true. And my lord, supposing they are found to be true, then these 3 figures, 3,24,000, 5,98,000, 55 crores. I do not know where was I. Malad, kindly see, we have seen, Malad, people struggling for bona fide causes for release under 48. Some school buildings, some part has also fallen. Your lordships have so much of experience. Nobody, Malad, gives you an ear. There something is developed. Acquisition completed. Plots sold. and my lord, de-acquisition and then sale of agricultural land which is not in existence. Now kindly come to the next judgment.
Yes.
My lord, if your lordship may come to the judgment, my lord, starts at page 91. On public trust doctrine, my lord, in that Noida Enterprises Association case, my lord, of 2011, 6 SCC, page, my lord, 508. Para 38, my lord, is 107.
10?
7, my lord. Para 38.
Yes.
The state or the public authority which hold the property for the public or which has been assigned the duty of grant of lodging acts as a trustee. Please now keep all, my lord, these observations in mind, these three figures, that they have to act as a trustee for that property, my lord, which is not worth less than 55 crores. Now, if it is a public largesse which has to go to a particular entity or a particular person of 55 crores, through this illegal and, my lord, completely unknown process, unknown to law in such a circuitous method, and, my lord, it becomes 55 crores when it comes into your hand. And therefore has to act fairly and reasonably. Every holder of public office by virtue of he acts on behalf of the state is ultimately accountable to the people in whom the sovereignty vests. As such, all powers so vested in him are meant to be exercised public good and promoting the public interest. Every holder of public office is a trustee. Then now para 39, 40, 41 and 42. And, my lord, that observation, my lord, as a respectful submission which I had made, that even for the framing of charges, the Supreme Court has said weaker than prima facie case, page 126, para 12, para 17. The judgment starts, my lord, at page 109, 126, para 17. Just permit me to read 2 lines. This is now, my lord, post 197, post 90. The court is applying its mind, and the court has to frame charge where it is fully equipped with the material collected, all evidence is collected, is to be considered.
Yes.
Framing of a charge is an exercise of jurisdiction by the trial court in terms of section 228, unless the accused is discharged under 227. Under both these provisions, the court is required to consider the record of the case and documents submitted therewith, and after hearing the parties may either discharge, etc. It shall frame the charge. The kindly see, my lord, next to skip 2-3 lines. Kindly see, my lord, the sentence between just 1 line above placetum C, the
Yes.
satisfaction of the court.
No,
Lord,
that
I'm at page
I've
1.
already seen and marked.
Sorry.
I was just saying, what was the offense in that case?
But this
It was
the-
abatement to suicide.
Yes, my lord, that lady had died. And then, my lord, this was the case where but this was the principle laid down. This is one judgment, my lord, which have been followed, but the words of this weaker than prima facie case, my lord, has appeared here.
Yes.
And the Supreme Court has laid down that as a test.
Yes.
138, my lord, your lordship may just make a note. Is a judgment, my lord, of the Telangana High Court, my lord, 138. Actually, it starts like this in the print from the High Court website.
Yes.
138. And your lordship may just mark bottom 138, bottom up to 140, up to 2 sentences on the top. This one paragraph which is unnumbered.
Yes.
I am placing reliance on this, my lord, where this public trust doctrine has been applied by them.
YS Rashekar Reddy.
Say in the Reddy's case.
Yes.
And then kindly come to my lord, page 291. In the same judgment, the last para.
Yes. Yes.
I just want to read this, my lord.
As discussed above.
Yes, my lord. As discussed above, your lord, I can save time, my lord. I can skip it. Your lordship may just make a note. This is the repeating and reiterating the
No.
same principle in this.
So if you just print this in your note that you give.
I will add it,
then-
but one or two things, my lord, which I want to show.
Yes,
I
yes,
want to
that's
show
all right.
4 or 5 paragraphs from my
Yes.
lord Indore development.
Yes.
Page 368, my lord. 368, Union of India versus Shiv Kumar Bhargav, 1995, 2 SCC, page 427, para 4,
Yes.
369.
Yes.
Just permit me to read it, my lord.
Yes.
The policy of the government, my lord, this was policy for land, my lord, alternate land development, etc. Land, a lot, developed land to be given. Person whose land was, the policy of the government indicates that the person whose land was acquired means the owner as on the date notification was notified for acquisition, and he alone will be entitled to allotment of alternative site. Now, my lord, the argument which your lordship would be required to deal with, whether the denotification is to be accepted at all or not before investigation. Because that may bring a change. But, my lord, when I say that the compensation determined, compensation deposited, and the land in the revenue entry is in possession, got developed and sold, then all these principles apply with full force. And that would be a subject matter of investigation, because as I said, my lord, I am not defending a 48 release. I am only showing a express impossibility of that. And therefore, there is apparent that things have been engineered and created. Page 378. 378, my lord, at 382, para 5. This is the case, my lord, celebrated judgment followed various sne parva, my lord, para 5. And the last, just above placitum D, the only right which he has is only for that monetary compensation. That's all. Nothing else. And this has been followed, my lord, repeatedly by Delhi High Court, my lord, which is at 384, at 398, para 9 and 10. Now, my lord, kindly come to thereafter 416. Here, my lord, the release was being made so that to enable to take away the land, my lord, for the builders. My lord, the Supreme Court considered this matter came from, my lord, Gurgaon, Haryana, where, my lord, the contiguous land, etc., the government was used to make larger chunks of land available to the builders because of the principle of contiguity. And, my lord, that where the Supreme Court heavily came down on such an exercise. And the relevant part is at 440. Para 24, 25, 30 and 31. I'll put it in my note. Just your lordship may just make a note.
Yes.
Kindly see, my lord, para 31. 31. Power to release land from acquisition has to be exercised consistent with the doctrine of public trust. Here it has not taken place. It's only generated now. So they are mutually they can't coexist. That is the development continuing after the award and the money compensation, development continue, development develop plots hold. They can't coexist. Now, my lord, 444 is the judgment in Shiv Kumar's case, my lord. Your lordship may just make a note from para 7 onwards at 451. Para 7, my lord, your lordship may just permit me to read one line.
Yes.
7 at page 451. We advert to the legal position concerning the purchase made on 5/7/2001, made after notification under section 4 had been issued under the Acquisition Act. Law is well settled in this regard by a catena of decisions of this court that an incumbent who has purchased the land under has no right. And kindly see the quoted portion from Jal Nigam in the next paragraph.
Yes.
That apart, Since Messrs so and so property, the respondent had purchased the land under notification 4-1 was published, the sale is void against the state. The quoted portion, my lord, para 7.1, para 3. It's void because the land has stood vested in the state. It's void. Kindly see para 8 at 455. It has been laid down, purchasers on any ground whatsoever cannot question proceeding for taking possession. A purchaser under section 4 notice does not acquire any right in the land as the sale is ab initio void and has no right to claim land under the land policy. Kindly come to my lord 4 paragraph, which I indeed, my lord, with your lordship permission, wish to read 465 in those development on 2 points, as I said, my lord, on payment of compensation and taking over the possession. 578. Para 116. My lord, just permit me to read 4-5 paragraphs here, my lord.
Yes.
It would be helpful for me to explain, my lord, and my lord, submit for your lordship consideration the points which I am raising. My lord, your lordship has seen that just one day before the honorable governor noted the letter is written by that my lord, the compensation is not paid one day before. Now, in that context, kindly see 116. It is apparent from a plain reading of section 16 that the land vests in the government absolutely when possession is taken after the award is passed. And I have brought made 2 submissions for your lordship kind consideration for a case made out prima facie for investigation is that, my lord, it already stood entered into the revenue record as the government as the owner. And, my lord, the compensation stood determined at 3,24,000 and, my lord, wherever to be deposited or given. Clearly, my lord, your lordship has skipped 4 lines and then, my lord, 2 lines above at last 4 lines. Once an award is made and possession is taken by virtue of section 16, land vests absolutely in the state free from all encumbrances. Vesting of land is automatic on the happening of the 2 existing exigencies of the passing award and taking possession as provided in section 16. One possession is taken under section 16. The owner of the land loses title to it and the government becomes the absolute owner. Payment of compensation under the act is provided under section 31, which is after passing of the award under 11. Please come to 119. Section 34 deals with a situation where any of the obligation under section 31 is not fulfilled. When the amount of compensation is not paid or deposited on after taking possession of the land, the collector shall pay the amount awarded with interest thereon. Because, my lord, your lordship may just keep this in mind, 31, 34 of the old act, that even if it is not deposited, what you can get is 9% interest. Please read this paragraph with me, my lord. The collector shall pay the amount awarded with interest at the rate of 9% from the time of so taking possession until it shall have been so paid or deposited, and after 1 year from the date on which possession is taken, interest payable shall be 15%. The scheme of the 1894 Act clearly makes it out that when the award is passed under section 11, and, my lord, our case is old act, this is applicable. Thereafter, possession is taken as provided under 16, land vests in the state government under section 12(2), notice of the award. Taking possession is not, please mark it, my lord. Taking possession is not dependent upon payment. Payment has to be tendered under section 31 unless the collector is prevented from making payment as provided and so and so. In case of failure under 31 or 31(3), the collector is not precluded from making payment, but it carries interest at the rate of 9% for the first year and thereafter at the rate of 15%. Thus, once land has been vested in the state, section 16, case of failure to pay the compensation under 31 to deposit under 31(2) has to be paid along with interest. And then, my lord, 4 lines thereafter, in a case where possession has been taken, etc., under 16 or 17, that emergency awards, etc. Then kindly come to para 128. 128.
Yes.
Section 48 is quoted, my lord. Constitution bench also deals with section 48.
Yes.
48 is reproduced. Kindly come to last 2 lines of 40, just above 129. In case possession has been taken, there cannot be any withdrawal from the land acquisition proceeding under. So, my lord, the question which is required for investigation, obviously the other side would say we have a notification of some 30th of May 1998 of deacquisition. But before that, my lord, in 98, the land revenue recorded the government is already the owner and the land is already a part of the development scheme developed and sold. So this would require investigation. And, my lord, if in the investigation, if my submission is found to be correct, my lord, that it is engineered and created later on, then all these principles, my lord, will cover. And they will apply with full force. Therefore, my lord, as of today, there would not be any, my lord, blockade or prohibition or impediment, not that there should be not an investigation by an independent agency to do this. Not those who are in, not by them, those who are unison with the petitioner. Now, my lord, kindly see one or two more paragraph, 129.4, which your lordship may just make a note, I am not reading. Page 659. With regard to possession, page 659, my lord, the title is Mode of Taking Possession, my lord, para 246 to 47.
Yes.
And, my lord, supposing in 247, a particular, my lord, entry on the file or some kind of a parchi to be drawn up for, my lord, the paper possession also. Who will find out where is that slip? Before it entered into the government revenue records and the possession is taken and it is given to the pool of the total 268 acres, my lord, for this third phase, which stood developed. It will only come out through that investigation. Because without this, my lord, it could not have been a part of the award and, my lord, the part of the development and, my lord, the entry in the revenue records in the name of the government. It was not possible. Those are the things, my lord, which have taken contemporaneously in accordance with law. Thereafter, my lord, the reversal has sought to be created. Page para 261, my lord, thereafter 246, 247. And, my lord, para 261. PC 261, first four lines, my lord, I am not reading it. Just see, my lord, what would the requirement. Even going to the spot is enough. And here,
Symbolical.
yes,
Even symbolic.
absolutely. And, my lord, even going is enough. And this is confirmed, my lord. Earlier there was a doubt whether, because, my lord, the new act now says physical possession. That also, my lord, the court has considered. Now, my lord, please mark that page, my lord, 669, para 266. And, my lord, 366, which is the last conclusive portion. And, my lord, few paragraphs which I want to read only, my lord, only to add what the learned solicitor and even my friend on the other side have read in Subramanian Swami. My lord, the compilation by the petitioner which is given, there is this page 271. Page 271.
Petitioner compared list of judgments. Whatever petitioner. Volume 1. 271.
Yes, add 283, my lord. Para 2 and para 3. This is a private complainant applying for sanction.
Yes.
Para 1 and, my lord, para 2 and 3, your lordship may just make a note because my learned solicitor general has read the other portion. Kindly
Yes.
just, my lord, for properly appreciating it, 2 and 3 may be relevant. It's a private complainant who goes and seeks a sanction.
Yes.
Para 10, my lord. And then he is compelled to file a writ petition in the High Court,
Yes.
which is para 10. And then kindly come to para 19.
Yes.
And what your lordships observed, my lord, it is only a prohibition against the police to proceed. It does not create a locus standi for somebody or prohibits a locus standi for someone else.
No,
And
that
my lord, your lordship may kindly see. My lord, if your lordship may kindly see 17A and
A.
19, your lordship must be remembering, only submission is this. If I ask a question to myself that who will not proceed is given, against whom you will not proceed is also given. Why is this that it is silent, that who will seek it?
No, that's immaterial. That's not.
No, my lord, I am saying that that is the incorporation of the doctrine of locus standi neutral in the criminal jurisprudence. It is the manifest.
If it were to be that an aggrieved person only can seek,
Exactly.
it would have been there. It is not that.
So therefore, Subramanian Swami explains, my lord, that since the crime is against the society, everybody has got the locus standi.
No, that's why it
And
is.
therefore, if your lordship may just see one paragraph here,
Yes.
para 30. Just see para 30, my lord, only for a moment at page 292
Volume 1, right?
of the judgment compilation of my friend on the petitioner, my lord. Your lordship was seeing this judgment of Subramanian Swami there. Volume 1. And my lord, the printed page, the page is not handwritten. These are the pages, my lord, which have come in a small font in the printing itself. This was given on the first day, my lord, Subramanian Swami's case. The learned solicitor had also
No,
read
that
some
is
more.
of which one, sir? You mean this?
यहीं से पढ़ देते हैं 28 से
Other good.
21, 30, 44 हैं
They are not even. Give that. Other third.
ये page para 28, para 30 and then 44. Para 28 your lord-
Page, sir.
page, my lord, it is कहाँ है page यार मैं भी नहीं देख 292
292. Yes, sir.
on the top, my lord, it is
Yes.
getting smudged, it's getting mixed
Yes,
up.
yes, yes.
Now kindly come to 28. Para 28. Page number is 292.
Yes.
The sentence starts, there is no provision.
There is no provision.
Yes, there is no provision either in the 88 Act or Code of Criminal Procedure which bar the citizen from filing a complaint for prosecution of public alleged to have committed offense. Therefore, the argument of the learned attorney general that the complainant cannot file a complaint for prosecuting respondent for merits rejection, then Antule, and then para 30. Kindly see para 30. While dealing with the issue relating to maintainability of private complaint, the Antule's portion is well recognized principle of criminal jurisprudence that anyone can set or put the criminal law into
Yes,
motion
that's-
except where so and so.
That's
And my lord, para 44.
Hmm.
Para 44.
Yes.
And para 44, and then kindly see 44, my lord, the middle of the line. By the third line, my lord, whether the facts placed before which in a given case may include the material collected by the complainant or the investigating agency.
Yes.
Kindly see that third line, my lord. Let me read it. We may have a grant of refusal sanction is not a quasi-judicial function, and person for whose the prosecution sanction is sought is not required to be heard by the competent authority before it takes a decision the matter. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency, prima facie disclosing commission of an. So source can be any, person may be any. Then, my lord, your lordship may kindly make a note, para 68 and 75. Para 68,
Yes.
today corruption, etc. 75. Now kindly see 75. Just permit me to read these few lines.
Yes.
Therefore, in every case,
Yes.
and this is also one of the, my lord, concurring opinion, in every case when an application is made to an appropriate authority for grant of prosecution connection with an offense under the PC Act, so my lord, please see appropriate authority. So whichever authority, whatever is needed, I as a citizen have applied.
Hmm.
So what is to be done now? For grant of prosecution connection with the offence, it is the bounden duty of such authority to apply its mind urgently in the situation and decide the issue without being influenced by any extraneous consideration. In doing so, the authority must take a conscious effort to ensure the rule of law and cause of justice is advanced. in considering the question of granting or refusing such sanction, the authority is answerable to law and law alone. Therefore, the requirement to take the decision with a reasonable dispatch is the essence. In such a situation, delay in granting censure proposal thwarts a very valid social purpose, namely the purpose of speedy trial with the requirement of bringing the culprit to book. Therefore, in this case, the right of the sanctioning authority while either sanctioning or refusing to grant is coupled with a duty. The sanctioning authority must bear in mind, and up to 77 that, my lord, they are saying that there should not be any delay in that regard. Therefore, my lord, if your lordship may kindly see at the cost of repetition, what I am submitting and making my humble submission, my lord, for this respondent is that sufficient objective material with their admission now through the form of their notes and document has come on record. And therefore, my lord, an investigation is needed. Whatever is required to me, either to file a complaint or to apply to the governor under 17A, whatever is applicable, I have done so, and my lord, in this jurisdiction under 226, notwithstanding who has invoked it. If your lordships are satisfied, my lord, that the case is made out, that the investigation should not be impeded, my lord, your lordship would consider that, my lord, and my lord decide the matter. That's my respectful submission, my lord, only with the liberty that I'll hand over my note with this,
Yes.
whatever I've read in, my lord, by today evening or by Monday.
Yes.
And Mr.
So-
Raghavan, my lord, has requested me to, my lord, we will supplement it on Monday, something. my lord. Grateful, my lord.
I have about half an hour more.
Continue,
Take it.
2:30. ಆಯ್ತು, 2:30.
Let's
You have concluded, Maninder Singh, sir?
Concluded.
Yes.
2:30.
Sir is also concluded? Yes. Continue at 2:30.
I may leave a little early today,
Yes,
but
sir.
I'll be there, while it's virtual or physical, when Mr. Raghavan is
problem, sir.
arguing, then I'll work out the dates with the lordship.
So you want to reply to the submissions already
I
made,
need
you
to
can.
put all this together now. There's
Yes.
a massive 61 page plus all these other things. I'll want to in fact take
That's
some
better.
time to put things together into one single
Yes, sir.
block, Palace. So
Yes.
in any case, Mr. Raghavan is arguing, so you can.
Yes, sir, yes.
take. So I was just.
Anyway,
I
my
may
lord,
be
I just
excused- I
clarification.
may be excused for the last half an hour or one.
No problem.
Considering, my lord, the scope of the present petition, whatever my learned friend Mr. Singh argued, is obviously only for the purpose of showing that it's not just a haphazard way of prosecuting someone. There is a material. So it's the scope of the petition would not include
While
defense, etc. my lord.
While your lordship is rising, this is not the right time, but I'm very, very touched by this slight, very mild caveat. I didn't interrupt Mr. Singh once, but it's going to be my argument that in my sanction, my learned friend has argued anything but sanction. He has argued merits.
No, that's
Every
what-
case he has cited
The
is a
reply-
case. He goes to the extent of saying in my sanction petition, your lordships can become a 226 court to grant him sanction. That's his argument.
No.
Not
Just
one
to
single
prima facie
sanction
show
case
that
is
there is a
cited.
material.
Argument is that there is abundant material.
No, he
Not
says
that you
anybody
can give
come,
your
therefore
defense
sanction
here
will be
and
granted.
get a acquittal.
Anyway, well, we'll
You
deal with
can't
that.
argue on defense.
Because locus neutral, therefore anybody can come. Governor must grant sanction. Because anti-corruption, public trust doctrine, we are arguing a sanction under 17A or 19 or whatever it is. Not a word about it. But anyway, well, that's why I need some time to analyze these cases, tell you what these cases are about. They are chalk and cheese, brothers. We're talking of North Pole and South Pole with the subject. So I'm concerned.
Yes. Yeah. We'll continue at 2:30.
Please.
Yes, thank you, sir.